The revolution is successful. The colonies gain their independence. But what came next? Independence gave the colonies the right to form a new government, but what form would that take? Sorting this out was the job of the Constitutional Convention in 1787. 7 articles were drafted for the Constitution, which defined the different branches of government and created the rules by which this government operates. The first article lays out the legislative branch of the government, Congress, which creates law by drafting bills. Congress is composed of 2 houses, the House of Representatives and the Senate. While both houses are composed of representatives from each state, the number and qualifications of these representatives differs for each house. Each state's number of representatives in the House is determined by their population. So, the more people in the state, the more representatives that state has in the House. On the other hand, each state gets 2 representatives in the Senate, no matter what. Also, all representatives must be at least 25 years old and must have been a citizen of their state for at least 7 years. But to be elected to the Senate, a representative has to be at least 30 years old and must have been a citizen of their state for 9 years. Along with having fewer members, this stricter set of qualifications has the effect of making the Senate the more senior and prestigious House of Congress. The second article defines the executive branch of government, which is headed by the president, who must be a natural-born citizen that is at least 35 years old. The president is given the job of executing the law, which means that they are given the power to sign bills into law and to enforce those laws. While the second article only defines the executive branch as having a single person, this was expanded upon by George Washington with his addition of a cabinet of advisors. This cabinet has since been added to and changed over the years, but is understood today to be an essential part of the executive branch. Article 3 lays the foundation for the judicial branch, which has the job of interpreting and applying the law. The judicial branch is primarily defined by this article as the Supreme Court, which has the Chief Justice. It also says that Congress is responsible for establishing the lower courts. Despite what you might think, it doesn't say how many justices must be on the Supreme Court, nor does it lay out how many lower courts there should be, or that there need to be any at all. These decisions would be made later on. This article also loosely defines the cases the judicial branch will hear and what constitutes treason. Article 4 defines federalism, which is the structure of the national government. It says that states must give full faith and credit to the acts, records, and court proceedings of every other state, which means that each state must respect the laws of every other state. It also says that the laws of each state must be applied equally to residents and non-residents of that state. This keeps people who are visiting other states from being discriminated against simply because they don't live there. This article also lays out how new states can be admitted into the Union and that each state must have a Republican form of government. What this means is that while each state can define the specifics of their government, the overall structure of the state government must be based on a republic. Lastly, this article protects the states from invasion by the federal government, as well as from any other states in the Union. The founders were very aware that changes might need to be made to the Constitution, and so wrote Article 5 to lay out how the Constitution could be amended. The first step in this process is by having an amendment be proposed. This happens either by a 2/3 vote of both houses of Congress, or by a convention being called by 2/3 of the state legislatures. Once an amendment has been proposed, it must be ratified by 3/4 of the state legislatures, or by conventions held in 3/4 of the states to become a part of the Constitution. So you can see, this is a very difficult thing to do. Article 6 covers a broad set of issues, but is mainly concerned with establishing the Constitution as the highest form of law, followed by federal law, and lastly, by state law. This article also ensures that all government officials must swear an oath to uphold the Constitution and cannot violate its law. Finally, Article 7 defined how the Constitution would be ratified by the states, specifically saying that at least 9 of the then 13 states in the Union needed to ratify this document in order for it to become the law of this new country. While this may have seemed like a no-brainer, at the time there was quite a bit of debate about the Constitution, especially from such famous names as Patrick Henry, Thomas Paine, and George Mason. They worried that since the Constitutional Convention was made up solely of landowners, that the rights of the average citizen would not be protected. The Constitution of the United States defines the major principles of the government, like the will of the people, the limitation of the government, and checks and balances, ensuring the separation of powers. But what were the criticisms of the Constitution leveled by thinkers like Paine and Henry, and were they valid? How were the dangers they envisioned accounted for in the Constitution? And how was the Constitution further developed after it was ratified? Let's find out.